So welcome everybody. I know we're expecting a few more people, but I thought maybe we just get started with some brand new news. You should be able to see my screen. Let's just see, actually, this is not the screen I wanted to show. This is the screen I wanted to show. As of last night, you can now execute wills in counterpart. So there is, if you go to eState on our blog, we have a description link to the emergency order. We have sort of an outline of what we think the process might look like. We have additional checklists now, and we've got affidavits of execution for counterpart. Now, as eState users, if you go to your portal, you'll see that there's already an affidavit of execution by counterpart available. So if you start using this right away, we have a sample affidavit of execution already available in your portal. So that's breaking news. You're hearing it. We just heard this. I just heard this at 9:49 this morning, and just getting launched now, and so just thought you should all know about that. Anybody, maybe we'll return to that after we work on some eState planner gifts and take you through some examples. There should be a, and I don't know if I'm the host or who's the host here, but there should be a chat available for anybody who wants to chat. I'm going to just do that, put that open. And yeah, I think everybody's here now. So we have about 25 participants. Welcome, everybody. It's Jordy speaking. And I just wanted to let everybody know that we've got, I'm just going to open that. We have some new legislation as of last night that allows for counterpart of execution of wills, which I will mention a little bit more once we later in the program. We're going to aim for about a half an hour today, but we can answer questions. So the focus on today's webinar, it's not a basic one where I'm going to take you through start to finish. It's going to be more advanced. It's for those of us who are using trusts in our planning, how to do that using eState Planner. And so we'll do some, we'll do an example Henson Trust, we'll do a residence trust, and we can do a spousal trust as well. So, and as always, open to questions. So if you want to put them in the group chat, that's great. Or I don't know if you're unmuted or not, but you can always jump in with any questions. So this is going to be more of a demo, but feel free if you want to try it out on your own portal with a client, feel free to do that. So we're going to take a, we'll start sort of simple. We'll use a qualifying spousal trust that we would create for a spouse. So let's go to any scenario, and you can create this kind of trust in any, either in a residue gift, the balance of the estate, or in an initial gift. Let's just do a balance of the estate residue gift. So let's assume that the instructions are that we're talking to the client about using a qualifying spousal trust for the residue of this of the estate. So we'll add a segment, and it's going to be, let's assume, for 100% of the estate. So we'll leave that segment 1 at 100%. And now we'll add a gift. Remember that creating the segment only creates the percentage. Now we have to add the actual gift. So let's go add gift. So we're going to pick trust because we're going to create a trust gift. And we pick the name of the spouse. So it's Susan Jones. I hope that's her name. And she will be the sole beneficiary because we're talking about a qualifying spousal trust. She has to be the sole beneficiary. It's for 100%. And now we go through the different requirements for the trust. So the first one is who's going to be the trustee. So you can either leave it as the same trustees as the executors, and that's fine, or you can change the trustees. So let's try changing the trustees. So we'll click off that, and we'll pick our different trustees for the qualifying spousal trust. So let's assume that we want Susan Jones, the spouse, to be one of them. Let's also assume that we want Scott, the brother, to be another one. So now we have 2 trustees for the spousal trust, and we might want to add an alternate. Let's say if Susan can't act, we want Richard. So the condition would be Richard, condition if, and then we pick the specific one. So Richard is a replacement for only Susan. So that's that. That's how we do that. We get rid of the other people. Otherwise, if we had both of them in there, he would be a replacement for both of them. In this case, we just want Richard to act in Susan's place if she's unwilling. So that's how you would do that. And then we go done. So we've created a trust with different trustees from the executor. The duration, remember this is a qualifying spousal trust, so the duration needs to be the death of the spouse. Okay, so that's that. Mandatory payments. So we're going to need to pay all of the income to the spouse throughout the trust for the rest of the life. So payment of income. And then the question is, when does the income start to flow? And you can change that. But in this case, for a qualifying spousal trust, we need it to start immediately on death. So we'll have the commencement immediately. You could also build in a trust different things that suspend that payment of income. Like you could say, oh, if they got, remarried or they became insolvent or something like that. But of course, if you did that, it would not be a qualifying spousal trust. So if you tried to do something like that, it would warn you. eState would say to you, this is not a qualifying spousal trust. Are you sure that you want to do that? So that's why we're not going to do this. We're not going to add any suspension or termination of the payment of income, or else we would taint that trust and it wouldn't be qualifying. We're going to leave the discretionary payments unlimited, but you could change that. So let me just demonstrate. So we can say it would still be a qualifying trust if we restricted the payment of capital. You can do that on a qualifying spousal trust as long as we don't have it payable to anybody other than the spouse. So let's limit the discretion on capital. Let's put some conditions on. So if we go to, I'll just go back for a second just to show you what I did. So I put in the type of discretionary payments are limited, and then I did add, and then I did condition. So I'm going to say that they can only encroach on capital, and you can pick one of these if you like, and say only if the spouse has used up their own assets. So my spouse is going to get all the income, but capital is only going to be kicked in if they use up their own income, as an example. Okay. And we're going to have, I think right now you can only pick one of those. We're going to actually build in so you can pick multiple ones, but we have that on our list. As you know, I have a long list, and that's one of them. But now the gift over. For a qualifying spousal trust, we're going to pick a special kind of gift over. It's going to be as per descendants only distribution. So in other words, when the spouse dies, whatever's left over is going to go as per what we set out in the descendants only distribution. Okay, that's probably the best way to do that. By doing that, it's going to say determine those beneficiaries as of the date of the life tenant of the spouse, not the date of the testator, right? If she survives. So I just wanted to point that out. That's a special kind of gift over in a qualifying spousal trust. And then go add. And then we've created a qualifying spousal trust. So I'm just going to generate a will with that just so we can see that. And I'm just going to export that right now. And then we can open it up to any questions about creating a qualifying spousal trust. Anybody have any questions about that? Or generating a trust for money. Anybody have a question about that, how we created that and those different features, duration, trustees duration, mandatory payments, discretionary payments, and gift over? Anybody? I think we are recording this, if I'm not mistaken. Is that correct, Michaela?
Jordy?
Yes, we are.
Jordy, you set this up in the residue?
Yes.
But you said you could also do it as an initial gift. Would it be much different?
No, it'd be exactly the same, except it would be for a specific amount. That's all.
Okay.
Yep. It would work. The same dialog boxes come up, the same options, everything comes up.
Thank you.
Yep. Anything else? I know a minute has never seemed so long as when you're generating one of these wills. There we go. So the export is finished. Now it's gonna just populate here. There it is. So I just want to show you the wording that came out, because part of getting used to eState is recognizing what gets generated based on what you put in. So I just want to take us to that specific QST. So remember, it's balance of the estate, so it's here. So it says, if my spouse is alive at the survival date, set aside the residue, which is called Susan's fund. Now, if you don't like it called Susan's fund, you could do a replacement, search and replace. You could do that, but I'm just going to leave it as Susan's fund. And then here's the appointment of the special trustees. So it's Susan and Scott, but if Susan becomes unable, Richard in place of Susan. So that's how that works out. And then it says, okay, trustees give the money, the residue basically, Susan's fund, to the Susan Fund's trustees, and they hold it and keep it invested until the death of the spouse, or we leave open the option to extend it past the death of the spouse in case for tax planning. That's pretty typical sort of language. And we say, okay, with respect to the net income, you have to pay all of it to Susan, commencing immediately. Then we have to deal with the income that's generated post-death, but prior to the spouse gift over date. And what we just say is pay it to the same beneficiaries who get the capital. And then we say, with respect to the capital, subject to this paragraph, you can pay as much capital as you want. But here's the condition. The power to encroach may only be exercised, and then this is the wording. Now, this might be something that you want to edit yourself in this particular case because you want to massage it to be exactly the way the client wants it, or the client might be happy with this. This is the standard wording that comes up if you make it conditional on that. And then it says, we didn't do a gift over because we didn't provide for the descendants only scenario. But what it would then say is, on the gift over date, deal with it the same way as I provided for if my spouse wasn't alive, except that update the word survival date to the spouse gift over date, update the word residue to the balance of Susan's fund, so it does it automatically. So that's how that works. Okay. Any questions about that, the spousal trust? So let's do a trust for, let's create a cottage. Let's just do a cottage trust. We could do it as a home trust, but let's just do a cottage. Sorry, I'm just going to add a cottage. And doesn't matter. It's Ontario because remember, we got to put the province in. And you're going to want to put the address in if we're going to identify it. So okay, so we now have a cottage. Let's plan for the cottage. So let's say that we want to create an initial gift of the cottage, a trust for the spouse. So we would drag and drop the cottage into the initial gifts. We're in the surviving spouse scenario, drop it, and now create a trust. So who are the beneficiaries of this trust? Well, let's take a simple one where it's just the spouse. And we're going to basically hold it until they get remarried, and then they're out. Okay. So we're going to leave the same trustees. I've shown you how to change the trustees. So let's go to termination of use. So this is when the trust is going to end. So we might have a few of them. We might say death of the beneficiary. Whose death? Susan's death. We might also have if she gets if she starts to cohabit or remarry, we're going to terminate the use. Okay. Maybe we also, if we're going to make her pay some of the expenses, maybe we also say if she fails to pay the expenses, we're going to terminate. Okay. Then we go down, and the next thing, condition, you can add conditions, but we're not going to add any condition. Expenses. So who's going to pay the different expenses? So when you're doing a trust for this, you can do it individually. So you can say, look, I want her to pay 50% of the ordinary repairs, and I want her to pay 100% of the property taxes and those kinds of things. If you want one or the other to pay all of the expenses, you can just click down here and it will shuffle all of the expenses. But I just want to show you how it would work if we did this, something kind of funky here, okay? If there's an expense that's not on our list that you want to add here, and you can just add it here, and let's, I don't know, condo fees. You wouldn't have this obviously, but you could go add, and then you could say who's going to pay those expenses. Okay, let's get rid of that. So now the question becomes, okay, who's going to pay the estate's portion of this? So here you have two choices. You can pick residue, or let's set up a separate fund to fund the expenses that are paid by the estate. So click on separate fund, and then add some provisions. So I typically go to amount, and we should change the order of this because that's usually what I do. I say amount, and so you have two main options here. You can say it's going to be up to the trustee to fix the amount of this fund that we're going to need, or you can put in a specific amount in that fund. I typically leave it to the trustee's discretion to pick an amount. So that's what I do. And so that's now covered the payment of the estate. And now we have a couple of options. Should this apply to any replacement property and allow them to buy any replacement property? And if so, do we need the consent of the beneficiary? Let's say they do. And then what happens to the balance? So let's say they sell this cottage and they buy a smaller one for less. What do you do with the excess proceeds? That's what's happening here. Do you want that to fall into the residue? Or do you want to deal with it in a specific distribution? You could say, great, I want any excess proceeds to go to, the Hare Krishna or whatever you want, or some other beneficiary. You can do that. That's what specific distribution does. But for now, for this one, let's just have that go to the residue. Then we have an option to purchase. So this is a comprehensive option to purchase. So let's say we give Susan the ability to buy the cottage from the estate. So this first resolution is if you have more than one person who can buy it. Now in this case, you don't. So we're going to have an option actually who you can pick that, and you won't have that show up. But this is, if you have more than one, are they going to buy it as equal tenants in common? Are you going to set a priority for one person to have priority over another? First Susan, then John, then Frank? Or is it going to be by random selection? If more than one wants to buy it, you have to pick them at random. Those are our selections here, but we are building other options as well. So typically we'll just say if more than one, in this case it doesn't matter because there's only one person who can buy it, it's Susan. So we're going to have the purchase price. You can either fix the purchase price and say, regardless of its value, I want you to be able to buy it for X dollars, right? Or you can say, I want it to be purchased at the fair market value at the date of the exercise of the option. If I only own a partial interest, so let's say each of them owns it as tenants in common and you're letting the surviving spouse live in half of the home, in essence, are we discounting the value for a partial interest or not? Because obviously owning a part of a property is not worth as much as owning a whole. And it's not even necessarily pro rata because a minority interest has less value generally because you can't deal with it. The next option is, how are you going to determine the value? Is it going to be appraisals, or are you going to use some other method? Again, we're building this out to include, letters of opinion from real estate agents, certified appraisals, things like that. But for now, let's just do that. You can also here put in certified real estate valuator. And I'm not exactly sure what that does. So let's try that and see what happens. Now, who picks the method? Well, it's going to be the trustees. That's pretty typical. How many valuations are we going to get? Well, let's say we're going to get 3. And if we're going to get 3, what are we going to do? We're going to average them. We're going to build in another option. Here you have an other, but you're going to have options to get rid of sort of common options like get rid of the top one or draft your own. But for now, average or other is your option. Who's paying for those valuations? The residue or someone else? Should there be a discount for notional commission? And if so, how much? So I typically put in 5% for discount. Now, if the residuary beneficiaries aren't happy with those appraisals, now this is less common if you've got 3, but do you want the beneficiaries to have their option to get their own appraisal and then average it with the estate's appraisals? That's what that does. And if so, how long do they have to get it? They probably have 30 days to get their own appraisal, something like that. And who's paying? Well, I want the beneficiary to pay for that. Okay. Now, the next thing is the timing. So the timing is how many days after the purchase price is fixed do they have to exercise their option? So I don't know, they give them 20 days or 60 days or 100 days, whatever. And then after they exercise the option, assume they exercise the option, how quickly do they have to close? So let's say 30. And then the proceeds. So what happens to the proceeds of sale when they have the option of purchase? Does it go to the residue, or do you want to do a special distribution? And a special distribution is basically like a residuary gift where you can divvy up the proceeds. And I just saw something that needs to be changed. So this shouldn't say excess proceeds. This should just say disposition of proceeds, right? Because they're not excess at this point. They're the option of purchase. So that's what we do. And then the gift over is probably going to go to the residue, right? That's typical in this kind of trust. If Susan's not alive, the residue is going to go to residue. Now you could build a similar trust if she's not alive in the second scenario. So that's fine too. And go add. And that's how you create a cottage trust. So while I'm going to just generate that document, we'll ask if anybody has questions about that. And as I say, we're building in some more flexibility. We recognize there are some options in trusts for residences that aren't yet available in the portal. If you have instructions, and I have that from time to time, where the instructions are different than the options in the portal, I just usually put that in my note on my note page, and I'll show you where that is. I'll just type, whatever the special instructions are. You can do that, or you can put it in. There's a special provisions section in the gift itself. So if you want to remind yourself, that will come up highlighted in your in the draft. If you ever want to do that, that's another place where you can do it. Obviously, we're never going to be able to get to a position where we've thought of every conceivable option that a client could come up with, but we're going to cover more of them, and hopefully the use of other will not be as frequent. So I'm going to be quiet for a second and see if anybody has any questions. Anybody try a residence trust yet? No? It's fun. Try it. Okay, great. Tano. That's excellent. It fits most cases, but as I said, we continue to build it out. And if you have we'd love to know if there's something, if you're doing a residence trust and there's something in there that doesn't give you the option that you want, will you just flip us a note and say, I just want to, my client wanted to do this and it wasn't in the portal. And then we can add it to our list, because if it happened with your client, it's probably going to happen with one of our clients or one of our users' clients. So let's build that option in, because we want to make this as fulsome as we possibly can. So here's what gets generated based on the residence trust. So let's just go there. So here's the trust for the residence. It's under a section called Trust for Residence. And this is on the condition that the spouse is alive. So with respect to the property, my interest in the property, and then it'll insert the address that I put in, right? So if you don't put in an address, it'll just say known as and then be blank. So that's something what you want. Now, if you want to put in the PIN, that's what this is highlighted. And you may just want to make sure that this is correct, that you've covered the proper definition. That's why we've highlighted that. So you can see this also covers, because we picked replacement, it's also going to pick, say, any other property purchased in substitution for, and that's used for a similar purpose. Now, you may not like the wording of that, and so you can feel free to change it. So the cottage beneficiary is Susan, the cottage disposition date is, on these factors, these events, conjugal relationship, remarriage, etc. There's a warning here that basically the default period for non-payment of expenses is 60 days, but if you want to change that, you should change it. And it says hold it. And here are the repairs. Remember, we did different percentages for the beneficiary. Well, the beneficiary is responsible for 70% of the ordinary repairs and 100% of the property taxes. And my estate is going to pay the balance. And so how are they going to pay the balance? They're going to set up a cottage trust fund and deal with it there. And there's some footnotes here to just by default, the excess income is going to go to, is distributed per the residue. So this is after the accumulations period. It's just thinking about that. So that's why that's, and then here is the, they can sell the replacement property. And then here is the option to purchase. So remember when we selected certified real estate valuator, it puts that in and highlights it just to make sure if you want to put something else in there, it would remind you. So I've never used that before, but that's what it does. And I'm not sure we need that. So that might be something we change. Here's the without discount for the fact that it might be a partial interest, averaging the valuations, 3 valuations. Here's the option of the residuary beneficiaries to get their own. Here's how you calculate the option price. It's an average. You have a certain period of time. You have 20 days after you get notice. Here's what happens if you exercise it. And then we have the fact that it falls into the residue at the end. So that's that. And if anybody's trying to do a different disposition, I'll just show you how that's done. So it's very simple in a sense that if you go to the gift over, actually, sorry, it's the option to purchase. I'll just edit that. If you want the purchase proceeds to go somewhere else, not to the residue, you'd pick specific distribution and then pick the beneficiaries you want it to go to. I want it to go to Kathy, or let's say I want it to go to the kids in a trust, right? So when Susan remarries, then I want the proceeds to go to Susan, to my kids in trust till age whatever, and you could add that kind of, at till 25 trust, that kind of thing, gift over, and you can build it out the same way a residuary gift works. Now, right now, that's only in the option to purchase. So what we have, it's on our list, and it's actually one of the first things we're going to be doing, is for any of these, you're going to have the ability to, whether it's an option to purchase or not, the proceeds going somewhere different. So rather than that going to residue, it going to a specific distribution. So we're working on that. We know that's an interest of many people, so we're on it, and we're waiting on some key elements of the just so you understand what's going on. We're doing some key elements in the back of the software, the back end, and once that's done, we can really do a lot on the front end, and we have a whole bunch of things we're going to get out. And like I said, we're aiming for the end of the spring to have that those major changes done. So the last thing I want to do now is a Henson Trust. So the only way it knows to do a Henson Trust is if the beneficiary is disabled. So in this case, let's go to people, and let's say they tell you that Kathy, the adult child, is disabled. So that's so you double click Kathy to open up her data box and click on special circumstances. And I've clicked off that she's disabled. So right here, and I can put in and I can type in here whatever I want. And I've checked off all of these boxes. And then I've gone save. I don't believe you need to check off any of those boxes necessarily, except the tab that says that they're disabled in order to create a Henson Trust. So now the estate knows that Kathy's disabled. So it's not going to plan for her, but it's going to know that if you plan for her to use a Henson Trust. So what I mean by that is, let's go to descendants only, because we want to set up a trust for Kathy. And let's say we want to set up a third of the residue for her. Okay, so we create a segment for 33.3%, and we go add gift. And the beneficiary, we're going to pick trust. The beneficiary is going to be Kathy. So this is how you would create a Henson Trust. So trust, Kathy, trustees, you could pick different trustees or keep the same. Duration, death of the beneficiary, because we want this to be a Henson Trust for the rest of her life. No mandatory payments, and unlimited discretion. Those are the key elements for a Henson Trust. If those are your 3 selections, death of beneficiary for duration, mandatory payment, none, and discretionary payment, unlimited. For a disabled beneficiary, it's going to know do a Henson Trust. And then we're saying if she's not alive or she dies, when she dies, it goes to her kids or otherwise to the client's other issue. That's a Henson Trust. So just to go back, the key to a Henson Trust is add the disabled beneficiary as a beneficiary, and make sure duration is death of beneficiary only. Mandatory payments are none, and discretionary payments are unlimited. Okay. I'm just going to generate that document. Oops. Everybody knows that we have that more simple template available as well if you want to try that out. And I promise to wrap up shortly because I know I want to get you out of here in half an hour, subject to anybody having questions. So let me just see if anybody has questions about Henson Trusts, how those are done, and you'll see the wording, the typical wording from a Henson Trust clause appears. One of the things I'm contemplating is a general Henson Trust clause for any disabled beneficiaries, so that regardless of if you're giving a residue a gift or an initial gift or whatever, it's going to say, okay, pay if this person is alive, use the provisions in paragraph 10, which is the Henson Trust, but I'm going to give people the option to use that eventually. Right now, it's not available. Right now, you create it in the residue, or you can create it as an initial gift as well, and it would know that in an initial gift as well. Anybody have questions about how that works?
Yeah, Jordy, I have one.
Sure.
If you have 3 kids, 2
Yes.
of them are disabled.
Yes.
And you have 2 separate Henson Trusts.
Okay, yeah.
First person dies, there's
Yep.
money in their Henson Trust.
Yep.
Parent wants it to go into the other party's Henson Trust.
Right.
Is there something that says that if money goes to a beneficiary that's subject to a trust,
Yes.
and they have a trust, that it's automatically going
Yes.
into their trust and not to them outright?
Correct. There's a provision in the template that's called additions to trusts. And so what it says is, if anybody inherits money for which there's a trust already, add it to the trust of that person. And for disabled beneficiaries, it goes on. It says specifically with respect to this, because we really don't want it to. We really want it to happen for a disabled beneficiary. It goes on to that's my blog that's coming out shortly. We really want to make sure. So let me just show you where that is. So remember, I just left in all the other gifts that we had done, but let me just go to the Henson Trust. So here's the Henson Trust. So if Kathy is alive, to set aside Kathy's fund, discretionary as to income, right? We want it all discretionary, but we need to deal with what happens if after the accumulations period, we have to pay it out to somebody. And what we don't yet have as an option is, so you pick in a portal who it's going to go to. So we have it, we have it as something that you have to manually put in. So because it's very unlikely, of course, usually by the end of the accumulation period, they're going to be paying it to the disabled beneficiary. They may or they may not, but we need to make sure it's payable to somebody else, to the extent that it's not payable to the disabled beneficiary. And so here's where you would put it in. Typically, you'd put among such one or more of my issue, other than, and then put the disabled beneficiary's name, then alive. But I left that open for everybody to draft that. As long as it's not, we want to make sure we give it to somebody. And then I put in this further paragraph that says, look, if none of those people are alive, I need it to be paid to charities. Because if we don't have that, it could vest back into the incapable person, and then that might not be a Henson Trust. So that's why I do that. Now, you can choose to do it any way you want, but that's just our recommended planning. So that's the income. And then obviously the capital is fully discretionary. And here are the two sort of key provisions, or not key necessarily, but the ones that you commonly see, that it doesn't vest in her. And the other thing is that I'd like you to take into account her access to government funding. So that's sort of classic from the actual Henson case. And then we just said it goes to her issue and then otherwise. I want to show you that additions to trust. So this is the additions to trust here. Now, because we don't have a gift over to her, if there was somewhere a gift over to her, it would put in the further clause that says, and specifically with respect to Kathy, make sure any amount is added to paragraph, whatever it is. Okay. So, but there is always this default one, which may be enough, right? So that's that. Anybody have any questions? All right. If anybody has any questions, the other thing I just wanted to reiterate for anybody who came in late is that we now allow, as of yesterday, last night, counterpart execution of wills and powers of attorney is available. So I believe that we had a webinar today in anticipation of this, and we didn't get the word until just after it ended that it came down. So we're going to have another Hull webinar tomorrow morning at 8:30. And so if anybody wants to join, we're going to speak specifically about how to deal with counterpart execution. So,
Jordy, would you record that if any of us are not available?
Yes, it's recorded. Yep.
Okay, terrific. Thank you.
Yep. And we have this blog. The other thing is this blog that we just got out about an hour ago takes you through sort of what we think updates the checklists, and it has the affidavit of execution. And I'm working on a blog about the testimonial and attestation clause that we may have up in the next 24 hours.
And where's the blog?
The blog is on eState Planner. So if you go to eState Planner, and if you don't log in, you'll go to blog right there. And can you guys see my screen? And
yes.
Yeah, and so it's under blogs, and all of our blogs are on here. The affidavits of execution for video, witnessing, now the counterpart blog. So they're all there under blogs. The other thing to reinforce is if you have questions, you can check out support and use just the Control F to search if you've got a question about Henson Trust. That doesn't appear. We do have questions about other kinds of trusts. So if you want to check that out, you can search that way. And we continue to add to this as we go. So explains about how to build trusts and things like that. Anything else? Any other questions? I'm going to probably defer questions about counterpart to tomorrow's webinar, if that's okay. But at least you guys know probably before, most of the Western world about this. So,
Jordy, sorry to take the time, but I missed the first part. Anything else that was covered before you got into the cottage trust? Just and I can follow up.
Qualifying spousal trust.
Okay.
Yep.
Did you record the session by chance?
It's recorded.
Fantastic. Yep. Thank you.
Yep.
Great work, by the way.
Thank you. Anybody have any other questions?
I may, Jordy.
Sure. Sure.
Unrelated to today's presentation.
Sure.
But will you be putting out a codicil template at some point?
Maybe. Yes, but we may. I mean, the problem is we'll put it on our list for sure. I don't know when, but I'm happy to send you if you want to see just a template sort of for a codicil. Happy to send that to you if you're interested.
Oh, I would be interested, Jordy. Thanks.
Just flip me an email, Blake, and I'll get that to you.
Will do. Thanks.
Anything else, guys? So next week, I think we'll do one. We'll do a different sort of intensive one as well on Thursdays. Tuesdays are general ones, sort of start to finish for beginners, and then Thursdays are more advanced topics. So maybe we'll do specific asset gifts and deal with that and how to deal with conditions and things like that. So that's what we'll do next week. All right.
Yeah, Jordy, sorry, one last question.
Sure.
I'm doing this, I've got this Henson Trust client going on. So basically the situation, again, there's 3 kids, 2 of them were setting up Henson Trusts.
Right.
Residue is going to be a third, so that's fine. But there's already a bank account with some money that's going to go into the Henson Trust for one of the kids.
Right.
So there's a bank account, 50 grand, and then a third of the balance.
Right.
A third of the residue.
Yeah.
Can this be done all at once, or do you have to do like an initial gift, set up the Henson Trust?
Yeah, I would just actually say that the bank account shall be dealt with as part of segment 1, because they're going to be named, right? So that's what I would do there. Rather than, I love that, Thomas, that you've got Roy back there. Is that Roy?
Is my video on now?
Yeah, that's okay. So yeah, so what I would just do is an initial gift, just create an initial gift. That one you might have to manually do and just say, you know, if so-and-so's alive, to transfer my, you know, to my bank account shall fall into and form part of segment 1 as a separate gift, or in addition to any residuary gift or something like that. I wouldn't do a whole separate Henson Trust unless it's a really sizable thing. That's how I would deal with it practically.
Okay, thank you.
Yep. Anything else? Well, thanks, guys. And of course, we always welcome questions. If you have questions, if you haven't had a one-on-one tutorial, please consider booking one. And you know, they're free and we're available. So don't sit and struggle. Just try and, you know, just get on. Flip us an email at support@estateplanner.com, e-stateplanner.com, and just set up a webinar for tomorrow, the next day, or next week, or whatever. Get you up and using it. And so thanks, everybody. Have a good afternoon. And for those of you, maybe we'll see you tomorrow morning for Hull webinar. Okay, take care, guys. Bye-bye now.
Thank you.
Thanks, Jody.
Pleasure.
Thank you. Bye.